Good morning, everyone. Thank you for joining us for Smith Amundsen's webinar on COVID-19, preparing for defaults, forbearances, and small business bankruptcies. We're going to go ahead and get started with the program. Just a quick reminder that if you have any questions, feel free to send them via the Q&A box, and we will reach out to you directly with answers to those questions after the program. In addition, a copy of all the slides will be included in our thank you that will go out later today. My name is Mike Cortina, and I will be a presenter along with one of my partners, William Hackney. Now, why are we having this webinar? Well, as everybody knows, COVID-19 has had a serious impact on our economy, and many businesses are experiencing significant financial challenges. So forbearances and bankruptcy information is necessary to be able to respond quickly to these challenges by lenders. As I indicated, my name is Mike Cortina. I've been practicing since 1998. And if you want to look up my bio after this program is done, you will see that I am also the author of a ridiculous number of articles and publications. So feel free to peruse those at your leisure. So I will be presenting on forbearance agreements. In particular, we'll talk about credit agreement statutes, an overview of the various state statutes that exist on credit agreements, and also tips for any forbearance agreement. Now, credit agreement statutes, as an example, the litigation about credit agreements started well before 1979, but this particular case in 1979, the McClellan case, is the perfect example of why these statutes exist. The McClellans bought this company with a loan from Banc Midwest. In 1985, the bank decided that they were not going to go and extend any further credit to the McClellans and called the outstanding loans. The McClellans turned around and sued the bank for breach of contract and fraud. They alleged that the bank had orally agreed to finance the operation of the company until the business became profitable. Now, that was one of the ones that really touched off all of litigation because literally hundreds of similar suits like that were filed around the United States because, primarily because some of these suits resulted in very, very large verdicts. 8 figures in the 1980s was a substantial amount of money. Legislators actually quickly responded to this by creating credit agreement statutes. It's referred to sometimes as a strong form statute of frauds. And the whole reason behind it is it prevents commercial lenders from being held liable for any actual or alleged oral agreements to lend, forbear, extend terms, etc. So the effect of these statutes is it actually did drastically reduce the number of lender liability suits. It also protected lenders from claims of oral agreements to lend money, modify terms, or have anything to do with credit agreements. And the nice thing is that courts have strictly enforced these statutes, even when doing so seemed excessively harsh. Now, when are these statutes applicable? Usually, I say usually, but not always. Only for commercial lending situations. And I suggest that you check with your counsel on whether or not any kind of particular credit agreement statute would apply for any particular deal. And when is a credit not commercial or sometimes just consumer? Different states have different terms or different ways of defining whether something's commercial or not. But the good rule of thumb is to follow the federal definition of consumer. And a consumer loan is generally for personal, family, or household purposes. So if the loan is for anything other than that, it's generally considered a commercial loan. Now, these credit agreement statutes have certain terms generally to be legal and enforceable. And these statutes in general state that any credit agreement between a lender and a borrower must be in writing, signed by both lender and the borrower, expresses an agreement to lend money or extend credit or forbear repayment, etc., expresses some sort of agreement, and then sets forth the relative terms and conditions. And those are the basic requirements of a credit agreement under these different statutes. Now, I say that because these requirements do differ slightly state from state. Just as a couple of examples, Arkansas, their statute, in order for it to apply, the amount of money at issue has to be at least $10,000. Anything less, then it doesn't necessarily apply. Indiana's statute, the document has to have not only those other basic terms, but it must state the loan amount, the rate of interest, duration of the loan, and also what the security or the collateral is for that loan in order to comply with the statute. So states differ, so check with counsel to see what applies in this particular state that you're dealing with. So just going on to some forbearance agreement tips. Now, I'm not going to tell everybody how to do a forbearance agreement from beginning to end. That would take much longer than the 15 minutes I have, but I am going to present a few different tips on forbearance agreements and tell you why some of these tips are needed. First of all, do not rely on loan documentation forms to comply. Many lenders have computer programs that generate loan documentation forms. And I will tell you that I have personally seen a commercial program that generated a change in terms agreement, not a forbearance agreement, but that's essentially why they used it. And that form did not require the lender's signature on an Illinois loan. As I stated earlier, that is one of the requirements. Both the borrower and the lender sign it. And sorry about that, it kind of flipped through this. And let me get back here. Wait, it's the beginning. There it is. Web technology. All right. Second tip, use legal counsel. Yes, this is a lawyer telling you that you should always use a lawyer. I know that, but let's think about this for a moment. Legal counsel will advise if a proposed agreement is legal or enforceable. A lawyer will also help you generate an agreement that will help protect you if you're the lender, or if you happen to be the borrower, will also make sure that your deal is fair. And let's be honest, using a lawyer, if the lawyer makes a mistake and the lender is not protected with this agreement, or the agreement falls apart for some reason, that lawyer is liable. Third thing, this is probably the most important tip in this list of tips I'm giving, but minimums are not maximums. By that I mean that there are certain basic requirements to fit under a forbearance agreement under the credit agreement statute. That's the bare minimum, but there's no maximum on there. You can use these forbearance agreements as an opportunity to strengthen your position. For example, if allowed in your state, that is in bold for a reason, because not all states allow confession of judgment clauses. Illinois, they are perfectly fine for commercial loans. Indiana, they are not fine for any type of loan. They differ from state to state. Again, check with your attorney. If it's allowed, might be something to consider adding to a forbearance agreement. Another thing is to add in there that a borrower can waive any prior liability of the lender in case the lender had done something that could incur liability that could be waived. Or we can have the borrower reaffirm existence of the indebtedness. We can have the borrower waive any existing defenses in there. You can even have the guarantor reaffirm their own guarantee. So just because it's a minimum for a credit agreement doesn't mean that that's all you can do. Strengthen your position. And as a lot of people say, KISS, keep it simple, stupid. Now, sometimes there is a need for a lengthy forbearance agreement document. If you have a very complex, convoluted deal, multiple forms of collateral, multiple events of default, a lot of things going on, sometimes there is a necessity to have a lengthy document to make sure everything is detailed. But if something is fairly simple, say forbearing, not going to have them held in default for not making payments for 90 days, but then begin making payments again, there's no need for a 20-page document to do that. Keep it simple as much as you can. Next, 5, be precise. Define any term that could have more than one meaning. I am literally dealing with this right now with a client. For example, if a forbearance agreement is they're agreeing to make payments be interest only for a certain amount of time. What is meant by interest only? Do we know the exact amount of the payment, or is there a way of looking at this document to say exactly how much the payment's going to be by using a formula or something? People think, well, how could there be more than one version of interest? Well, at the bottom here, we say straight line interest based on the principal amount of the interest rate, or is it interest based on the amount of interest the borrower is to pay according to an amortization schedule of the different loan? Which is it? If you don't define it or say the amount of the interest payment or put the formula for it, it could be confusing. In addition to being precise, be accurate. Make sure that the person signing the document actually has the authority to do so. You do this when you start initiate the credit to begin with. So make sure that the person who's signing it has that authority. For example, if you have an LLC and a member of the LLC says, I want to enter into a forbearance agreement. Well, if that LLC is manager managed, not member managed, and that member doesn't have authority to bind the LLC, you've got issues if you go ahead and enter into an agreement with the member when that member didn't have authority. Next, review the file. Now, if a borrower comes to you seeking a forbearance of something, that is a great time to look at the file. See if you have any other issues you need to be aware of. Perform a collateral evaluation. Check for insurance. Look for compliance with the loan in any other way, shape, or form. Make sure that your collateral descriptions are accurate. If it's real estate, for example, make sure that the legal description encompasses all of the parcels of property that were intended to be covered. It's a good time to take a look at the credit to see where it is, if there are any other issues that need to be addressed. Attorney's fees. Usually, every commercial loan document has the borrower paying for the lender's attorney's fees. Well, the forbearance agreement could be the exact same thing, and you can also always require the borrower to pay for the lender's fees. And payment should probably be made upon execution of the agreement, because the last thing that a lender wants is to suddenly have even more indebtedness that the borrower was supposed to pay but didn't pay later on if for some reason the forbearance agreement is not successful. So what we have just discussed are the credit agreement statutes, why they exist, and how they are an aid to lenders. And we've also gone over tips on forbearance agreements. And as a last thought for my portion of this presentation, just remember that forbearance agreements are legal documents that bind lenders and borrowers. They can be used to everybody's benefit, but they must be properly drafted in order to comply with the law and provide the best possible coverage for the lender. Now I am going to transfer control of this PowerPoint presentation to my partner, Bill Hackney. Again, I would like to remind everybody that if you do have questions, feel free to use the Q&A box, and we will reach out to you after the program. And again, everybody will receive copies of the slides once the program has been completed. Now, as soon as I find
Okay. So first off, thanks, Mike, for taking us in. Thanks for everyone for attending. I'm going to be talking a little bit about the Small Business Reorganization Act. The act was passed and signed by President Trump at the end of last year and became effective in the middle of February of this year, right in the midst of the COVID-19 pandemic. Basically, what the Small Business Reorganization Act does is it creates a new Subchapter 5 of Chapter 11. For anyone who is at least semi-familiar with bankruptcy, Chapter 11 is the reorganization statute, which allows corporations and some individuals, but usually corporations, to file for a reorganization of their business and their affairs. And Subchapter 5 is aimed specifically at small businesses. So for those of us who are familiar with Chapter 11, the new scheme under Subchapter 5 will be completely different than the Chapter 11 process we know today. So the first thing I'll talk about is eligibility. You need to be a small business debtor, which is defined in the statute, and you must also opt in to the provisions of Subchapter 5. In other words, you can't just say, I'm a small business debtor. You actually have to notify the court and other parties that you are electing to be treated as such and operating under the provisions of Subchapter 5. As I mentioned, there is a definition for small business debtor in the statute, which once we get to the slides, you'll see. But the most important part of those definitions is that the small business debtor must have a debt cap of $2.7 million. In other words, aggregate, non-contingent, liquidated, secured, and unsecured debt must not exceed $2.7 million. However, in the time of COVID, things are changing very, very fast. And even though the SBRA was just enacted or just became effective in February, the CARES Act has already changed a very, very important provision of SBRA, and that is that debt cap that I just mentioned. Section 1113 of the CARES Act actually increases that debt limit, for a small business from $2.72 million all the way up to $7.5 million. So first thing you want to do if you run across one of these cases is check those debt limits. Previously, as I said, 2.7, now increased to 7.5 million to be eligible as a small business debtor under the Subchapter 5 of Chapter 11. That increased cap limit is expiring in 1 year. So what we're kind of projecting on our end is that we will see a wave of these Subchapter 5 filings in the next probably 3 or 4 months as issues with the PPP loan initiatives and the other disaster relief loans from the SBA kind of come out and are spent. We're going to see a wave of these filings, and then you'll see another wave closer to March of 2021 as the debt limit increase begins to expire. So one of the first things that needs to be mentioned as a major, major difference from previous Chapter 11 practice is in Subchapter 5 of Chapter 11, you are going to have an appointment of a Subchapter 5 trustee. And that is going to be required in every single case that's filed under this subchapter. The Subchapter 5 trustee is a completely new and different role. The Subchapter 5 trustee is not a trustee in the normal sense, in that he does not or she does not take possession of any assets and does not operate the business. The Subchapter 5 trustee's duties are really to supervise the case, manage the case, and assist, most importantly, assist in the plan process. For those of you who aren't incredibly familiar with bankruptcy and Chapter 11 and how that works, one of the goals of the Chapter 11 process is to come up with a plan by which the debtor agrees to pay back its creditors over time. And one of the main goals of the SBRA is to force both the debtor and all of its creditors to try and attempt to come to a consensual plan. In other words, a plan that everybody agrees upon. And that is one of the Subchapter 5 trustees' main goals. As part of those goals, the Subchapter 5 trustee will review the debtor's financials. He will be accountable, he or she will be accountable for the property received. He or she will examine proofs of claim. He or she will provide information to parties of interest. So whereas before, in Chapter 11 cases, you had the appointment of an unsecured creditors committee, which did a lot of these things and conveyed that information on to creditors. there will be no unsecured creditors committee in these Subchapter V cases. There can be upon special order of court, but there isn't one in the normal course of these cases. Therefore, creditors will need to rely on this Subchapter V trustee, and a Subchapter V trustee will serve as an independent third party to assist in that function. The other main goal, or another main goal of the SBRA, was to speed up the process of Chapter 11. For anyone who has been, in a Chapter 11, especially a large Chapter 11, you know that these cases can go on for literally decades. The SBRA meant to address that right off the bat and has done so through some very strict timelines, timeframes, and deadlines. The first one of those is upon case filing, the court will automatically set a mandatory status conference not later than 60 days after the order for relief. The order for relief is normally the day the bankruptcy case is filed. So within 2 months, you are forced to attend the status conference in front of the court. The purpose of that status conference is statutorily defined as, quote, to further the expeditious and economical resolution, unquote, of the case. So you can see from very early on, the statute wants the debtor, the Subchapter V trustee, and its creditors to be working together to come up with a consensual plan to resolve this case and get the small business debtor out of Chapter 11 as soon as possible. The next important time frame and deadline is there's a mandatory report which needs to be filed by the debtor not later than 14 days before that status conference. And the statutory purpose of that report, quote, details the efforts the debtor has undertaken and will undertake to attain a consensual plan or reorganization, unquote. So again, we see statutorily defined duties and obligations of the parties here to meet in the very earliest stages of these small business cases to try and come up with a consensual plan of reorganization. And I'm going to emphasize that again, not just a plan of reorganization, a consensual plan of reorganization. So creditors on this call, don't be surprised if you are getting calls from the Subchapter V trustee in these cases attempting to work with you on terms for your repayment under a consensual plan of reorganization. I think that's going to be a very usual, customary event in these types of cases. The next deadline and time frame I want to talk about is the date that the debtor can file a plan, and that is no less than 90 days after, or excuse me, no greater than 90 days after the order for relief, which again is the date usually that the case was filed. So 3 months we have from filing of the case to when the debtor must file a plan. And I emphasize the debtor must file a plan because unlike normal Chapter 11 cases where you can have competing plans, in a Subchapter V case, the debtor alone has to file a plan, and it must be done within 90 days. Compare that to 300 days under the current provisions of Chapter 11 for small businesses. You see a drastic reduction in time, and again, an emphasis on trying to get these small business debtors in and out of Chapter 11 as soon as possible. One of the most important, I think, aspects of these cases, though, in terms of the debtor-creditor relationship comes in confirmation issues. And again, from anyone who's not familiar with the confirmation process in the Chapter 11, that process is really the process by which the creditors vote to approve or reject the plan of repayment that the debtor has put forward. And they are able to either accept or reject whatever plan the debtor puts forward. Now, I don't know if you can see the slides yet, but in this slide, it talks about confirmation issues. The requirements that are involved in a regular Chapter 11 case are imported to a Subchapter V case in terms of a consensual plan. And that makes sense because if everyone's in agreement on how they want to be treated, there's no issue there, right? There's nothing really to talk about. The consensual plan, it should go through confirmation fairly easily. The difference really comes up here, and the important part for creditors here is on a cram down of a Chapter 11 plan in a Subchapter 5 case. And the reason this is important is because under the new Subchapter 5, a debtor can propose a plan which no creditor class has agreed to and still have that plan confirmed if certain things are met. The other thing that Subchapter 5 does, which is a very, very different requirement than previous Chapter 11s, is it eliminates the so-called absolute priority rule. And the important part of eliminating the absolute priority rule, I will discuss, and let me actually describe the absolute priority rule first, just in case anyone doesn't know what the absolute priority rule is. The absolute priority rule is a rule that requires junior classes of creditors and equity holders not to receive any distributions in the bankruptcy case from the plan of reorganization unless and until every class above it, in other words, the senior secured, the administrative expenses, your tax priority claims, all of those claims above it in the distribution scheme have either voted to accept the plan or are paid in full. That's the absolute priority rule. In other words, the people at the lowest end of the totem pole, which are usually the equity security holders, can't get paid unless everybody above them is paid in full. Now, in previous cases, that's really, really challenging for small business debtors to do, and it really dissuaded a lot of small businesses from filing Chapter 11 cases because that was a hard requirement to meet, and they didn't want to lose control of their business. The impact of that here is that you can have owners of these small businesses, which, sometimes are literally mom and pop. They might be brothers, might be small families, whatever it is. It's usually small, closely held companies. They can propose and have confirmed a plan with which no creditor has agreed and still retain all their equity in that business. That is a monumental shift in the power and the leverage that a debtor has in these small Chapter 11 cases. However, to do so, the trade-off for that is that the debtor must also show that the plan is fair and equitable. And basically what that means is that for unsecured creditors, they have to impose a disposable income requirement, there's a feasibility filing, and there must be an enforcement mechanism in the plan. In terms of a disposable income requirement, the trade-off for getting rid of the absolute priority rule and the ability to retain all of their equity in these companies as they go through bankruptcy is that the debtor's plan must provide that all projected disposable income for the 3-year period up to 5-year period be put towards repayment of its creditors under the plan. So again, they have to prove to the court that they are dedicating a large chunk of their revenue, their projected disposable income, to repayment under this plan. And this is also where the Subchapter 5 trustee is going to kick back in, because the Subchapter 5 trustee will be reviewing that to make sure that that is a viable alternative or option for these debtors. And in fact, that's reflected in the feasibility finding that I mentioned earlier. The Subchapter 5 trustee will be part of the confirmation process, and along with the debtor, will have to establish that the plan that they are proposing, the payments they're under, are in fact feasible in order to get this plan approved over the objections of creditors. Finally, the last thing that a small business debtor has to get established before they can have a non-consensual plan confirmed in one of these cases is that there has to be an appropriate remedy section in the plan. In other words, there has to be some enforcement mechanism built into the plan that allows creditors some type of remedy if the debtor defaults under the plan. So this is really where creditors, I think, can exercise their own leverage, is in getting these enforcement mechanisms built into the plan, so once or if the debtor defaults, the creditor can take immediate action and do something about that default. Finally, the last thing I want to mention is the administrative expense claim. In previous Chapter 11 filings, administrative expenses had to be paid on the effective date. The administrative expense is basically any expense that was incurred during the time of the Chapter 11 case but not paid. And that could include the debtor's own attorney's fees. So as you can imagine, administrative expenses sometimes became very, very large claims. They had to be paid usually in cash on the date the plan was confirmed, basically. That was a major hurdle to many, many small business debtors who simply didn't have large amounts of cash lying around. The new Subchapter V allows those same debtors to spread out all of those administrative expense claims, including the claims of their own lawyers, over the entire life of the plan. So again, it's making it much, much easier for these small businesses to survive, thrive, get in and out of the Chapter 11 process easily and quickly. So my last slide, again, I don't know if we have the slides yet or not, but my last slide is just the takeaways. And the takeaway, number one, is the SBRA drastically alters the debtor-creditor relationship. Creditors will need to work much more closely with the debtor and the Subchapter V trustee towards a consensual plan. And keep in mind, the SBRA is really pushing consensual plans, and I think the judges who interpret these things will also be pushing all the parties towards consensual plans. Maybe most important for owners and the businesses themselves is that the owners of the small businesses will be able to force their plans onto creditors, even though no creditor has consented, and still retain all of their ownership of the business. As I mentioned, that's a huge sea change in this type of filing. And then lastly, again, the possible wave of filings here as we continue to see an economic slowdown. I don't see any way around at least a significant number of these filings coming up in the next 3 or 4 months. And then, as I said again, in early 2021, before the debt cap goes back down to the $2.75 million. Again, I apologize. I realize that was a lot of information in a short amount of time. I don't know whether you ever got the slides or not, but you will get them in the email. The slides also have my phone number and email in them. Feel free to call me anytime, day or night, with questions about this. It's new. There's not a lot of case law out there on it yet, so it's kind of the Wild West. People are feeling their way through it, and we'll get through it. But we just wanted to make sure that that you guys were all aware of it and that we were on top of it. So with that, I'll turn it back over to Mike.
All right, well, thank you. Everyone, that concludes our program. Again, I do apologize for the technical difficulty. Hopefully the workaround we used made it so everybody was able to see the slides. But again, as Bill mentioned, if anybody has any questions, feel free to email us or give us a call. And everybody will be receiving these slides in their thank you email. And with that, I believe our program is concluded. So thank you, everybody, for attending, and have a good weekend. Goodbye.